clerk's desk. Just make sure there's not too much background here. Oh. All right, and this is a podium mic check, microphone check. Judge 1, mic check. Judge 2, mic check. Oh, that's loud. Judge mic 3, check. I have to turn that one up. Judge mic 4, check. Judge mic 5, check. Judge mic 6, check. Judge mic 7, check.
having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting at the Law Court at Bedford within and for the state of Maine, may come forth and declare it, and they shall be heard.
Good morning. You can be seated. The first matter before the court this morning is WCB 24339, Lorri Bosse versus Sargent Corporation. I see counsel are present. We are being streamed live on the web, both by audio and by video. If counsel who are arguing would introduce themselves by saying your names for the record, starting with the appellant.
Christopher Schlett on behalf of Sargent Cross Insurance.
Jim McAdam representing Lorri Bosse.
Thank you. Attorney Schlunt, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Honor.
May it please the court, I represent Sargent Corporation and Cross Insurance TPA. Thank you for having me here today to address this issue. This case involves a very important issue in workers' compensation. That is the calculation of an injured worker's average weekly wage. This issue is important because an injured worker's average weekly wage determines their compensation rate during their disability. Average weekly wage is foundational to the workers' compensation system. It is the basis for all lost time benefits, and it is also the amount of money that represents an employee's pre-injury earning capacity. It is important that an ALJ uses the correct method of calculation in determining an injured worker's average weekly wage. If an incorrect method is applied and an incorrect average weekly wage is used, that could have a great impact on the benefits received by an injured employee, as well as the benefits paid by the employer insurer. While Section 102.4 of the Act provides some guidance in how to determine an injured worker's average weekly wage, there are still situations where questions arise as to what method is the appropriate method to determine that wage. Section 102.4 provides 4 different methods to calculate an injured worker's average weekly wage. Those are subsections A through D. When presented with these situations, the ALJ and the board need further guidance on what average weekly wage should be, what method should be used to calculate an average weekly wage. Regardless of what section is applied to a calculation of an average weekly wage, the objective remains the same: to assess a fair and reasonable estimate of what the employee in question would have been able to earn in the labor market in the absence of the work injury. Here, the parties can see that neither subsection A nor subsection C apply to the present case. Subsection A does not apply because Ms. Bosse did not work for 200 days in the year immediately preceding the injury. Subsection C does not apply because that applies to seasonal employees, and the cutoff on that is 26 weeks. The worker would have to work less than 26 weeks, and here, Ms. Bosse worked more than 26 weeks. Instead, this appeal involves the issue of whether subsection B or subsection D applies to the present matter. Subsection B applies to situations where an employee worked less than 200 days in the year preceding the injury and whose weekly earnings varied. In calculating average weekly wage under subsection B, you take the total earnings of the employee with the employer and divide it by the number of weeks worked. Subsections A, B, and C are mechanical. Sometimes the mechanical calculations result in an unfair and unreasonable estimate, such as the case here. When an average weekly wage from subsections A through C result in an
Counsel, I see that the green light is on, which means we can ask questions. Can I back up a little bit?
Yes, Your Honor.
In this case, the application of subsection D depends on a finding that the application of B cannot be reasonably and fairly applied, right?
That's correct, Your Honor.
In this case, the ALJ found that it could be reasonably and fairly applied, right?
That's correct.
Isn't that a factual finding, and shouldn't we be dismissing this petition?
No, Your Honor, because the average weekly wage, subsection D specifically calls for if the result is unfair and unreasonable. Evidence was presented to the board that the average weekly wage was unfair and unreasonable.
And the ALJ said it wasn't.
But statutorily,
Are you saying it was per se that the ALJ had to apply D And if so, what's the test that you're saying had to be applied? Because we can only look at the legal test as opposed to the factual finding.
Well, in section 1024D, the statute explicitly states that due regard must be given to the injured worker's prior earnings and wages. That was not done in this case. The ALJ did not give due regard to the prior earnings.
And other employees of the same, similar class, working same, similar employment. I mean, there's no question that the 1,000 and some odd represents a reasonable average weekly wage for a truck driver, is there? Your issue is that she didn't work the full year. But I mean, in terms of the weekly amount, there's nothing wrong with that number, is there?
No, you're not per se, but it's not a per se standard. It's a fair and reasonable standard, and the judge...
Sounds like a facty thing to me.
The judge here determined that the average weekly wage on its face was per se not unreasonable. Anything per se can be found not unreasonable because it's viewed by itself. The statute explicitly calls for the judge to give due regard to the prior earnings and wages of the injured worker.
Well, they did, the ALJ did look at that, and the appellate division said that it wasn't per se, so they obviously said you did look at what the disparity was. Are you saying that the disparity, it was so big that it had to be, that's the test? You look and see if there's a big disparity? If you are creating the test, you said we have to give guidance to people. In a nutshell, what do you say the test is?
I'm saying the test is the fair and unreasonable standard in subsection D.
That's
And that
pretty-
is
That's
in
what it
giving due
is.
regard
That's what
to-
was applied.
But you're saying that it wasn't fairness and reasonable. How do, you said you need guidance as to how to apply. So we need a little more legs to this test so that people know how to apply it. What are the factors that you look at that weren't looked at here? Not enough regard to disparities in salary, or what are you saying went wrong here?
I'm saying what went wrong is when Ms. Bosse's average weekly wage that was calculated based on the weeks that she worked, it did not give account to the weeks that she did not work. Therefore, it extrapolated what her average weekly wage during her employment over the weeks that she did not work. And
But hasn't the legislature already dealt with that in subsection C by drawing a line at 26 weeks?
Yes, Your Honor, for seasonal employments. But here, and the split comes with the board, they are unsure of how to apply this. I've had some cases where there's earnings imputed for the weeks not worked because such as the minimum wage.
Does this turn on the fact that she gets laid off every year at the same time?
Yes, Your Honor.
And the employee says, what you're creating here is a de facto seasonal worker scenario, which is dealt with separately. A blueberry worker only does the harvest every year. It can't go beyond that because that's the end of the season. But in this instance here, there's a call for truckers through year-round, but the business may contract, and she has been on the layoff end of that, and which is fundamentally different than the seasonal worker analysis. So doesn't your analysis fail on that point there, to say that she's basically a truck driver who got laid off, she has an injury that prevents her from working? Isn't the case closed at that point?
No, Your Honor, it's not, because you have to look at her history. She historically worked this trucking job where she was laid off every winter.
Okay,
Come
so
spring,
if we
she-
have to look at her history, do we have to also look at how much she received in unemployment during the layoff period or other sources?
Well, that's-
And whose burden is it? Isn't it the burden to show that she earned, in other words, if you as the employer are arguing that D should be applied, that you want to apply the fallback, then aren't you the one that has to ensure that all the earnings are on record in order to show that B is not fair and reasonable and disproportionate? I mean, you can't just limit it to the actual earnings, can you?
Your Honor, I'm glad you brought up the unemployment, because that is a factor that has been used in other appellate division cases and other workers' compensation board cases. Sometimes the unemployment earnings have been imputed for the layoff period to counteract the unfairness that would result if the average weekly wage during employment was stretched out over that layoff period.
Right, because if she's not laid off, if she's not working for Sargent and therefore doesn't have that layoff period, she's also not going to get the unemployment.
But she could have another job where she's making minimum
could.
wage or something. We don't know because that wasn't explored here.
Well, my question is, you are the party who were asking that D be applied. Isn't it the burden on you, on the employer then, to ensure that all earnings or all types of income are on record in order to show that the application of B is in fact not fair and reasonable?
Well, Your Honor, the employee in this case testified that she did not work the year prior to the injury.
But she also testified that she had received some unemployment.
Past years, not the year prior to.
But she didn't volunteer, I don't want to go too far down the voluntariness road, I'm not sure that's a good road to go down, but she didn't choose to be laid off. She would have worked the rest, didn't she testify? She would have worked the rest of the year if she was not laid off?
She testified to that, yes, Your Honor, but she also testified that at the time it was the agreement that she knew she'd be getting laid off. And as far as the voluntariness is concerned, every spring she voluntarily came back to the job knowing that she would be laid off
But
the following
isn't there
winter.
a factual finding that it in essence wasn't voluntary? She would have kept working, and that's not a factual finding we can disturb, correct?
No, Your Honor, it's not. But she did not work during that layoff period.
Well, you said she knew that every year she was going to be laid off, but that's not necessarily the case based on this record. There are indications that there are other employees of that, of Sargent, who in fact weren't being laid off on the same, winter timing.
Yes, Justice Lawrence, that's correct.
And so she could have been, presumably, if she was meeting all the other requirements, she could have been eligible to be one of those employees, could she not?
That's correct, Justice Lawrence. But it's also in the record that she knew that that was not the case with her employment. And she continued to come back every spring knowing that she would be laid off the following winter.
Well, hope springs eternal, perhaps.
I'm sorry?
Hope springs eternal, that she can get over the hump.
Yes, Your Honor. And back to the big issue here is Alexander. Alexander dealt strictly with the voluntariness of the employee in that case. He voluntarily withheld himself from the labor market. The court's analysis in Alexander did not address the prior earnings, the prior wages that he may have had, so I don't really know if that came into consideration there. Here, while she didn't voluntarily get laid off, she voluntarily returned every spring. And the issue here, which was raised to the appellate division, was that her earnings, based on B extrapolated over a 52-week period, nearly doubled what her earnings were in the prior years.
Would your case be stronger if she testified, yeah, I like the layoff, I like to have the winters to myself, so I come back to work because I don't want to work the winter months? But your case would be stronger if she testified that way?
It may be, Your Honor, but I think
But she didn't.
I think here, even if you take her average weekly wage under B and take the compensation rate from that average weekly wage, which is $1,100, and extrapolate just the compensation rate over a 52-week period, that's still more than what her prior earnings were, $40,000 versus $33,000. And the legislature's intent, Your Honor, was not to afford workers that are injured higher earnings than they would have had working.
Thank you, counsel. And I believe you reserve some time for rebuttal.
Thank you.
Attorney McAdam, we'd be happy to hear your arguments.
Still morning? Good morning. I had the pleasure of representing Lorri Bosse for almost 10 years. She is probably, if not the hardest, one of the hardest workers I've ever represented. She got her CDL license back in 1990, which qualified her to drive a truck. And this is not an ordinary truck. This is a big, heavy dump truck, which they ride over rough surfaces, over rough roads, and get bounced around all inside the cab. During the first 10 years, she and her husband owned their own trucks and drove. She was self-employed. I don't know if everybody remembers Graziano's in Lisbon, but she worked there as a waitress to supplement her income. And she worked weekends and nights doing that. And she always worked 7 days a week. After their business closed down, she went to work for Gendron and Gendron, and she worked for them, I think it was about 10 to 12 hours a day, and looked for another job with Sargent, because Gendron and Gendron didn't want to pay overtime. She then went to work for Sargent, and when she got the job with Sargent, even though Gendron and Gendron wouldn't pay her overtime, she felt the need to give them a 2-week notice before she went to work for Sargent, and that's what she did. For Sargent, she worked a lot of hours too. And she said, and the hearing officer found, that she would have worked year-round if she was permitted to. Other men were allowed to, she wasn't. You know, I don't want to get into that it was discriminatory, but it appears to be. And she went back to work for them as soon as they called her back. And while she was laid off, she worked as a waitress again. She collected unemployment. As a requirement of unemployment, she had to apply for several jobs a week, which she did. And most of them wouldn't hire her because they knew that as soon as she got offered the job back with Sargent, that she was going to leave. And that's what she did. And Sargent actually paid her, and this is not in her wage statement, but they paid her a mileage supplement. If she had to drive more than a certain miles from her house, she got paid $20 a day. And there was another period where if she worked more than a certain number, they'd give her $30 a day. And if she was working overnight, they would pay for her hotel room.
So I see the green light is on.
Yep, I see
And
it
I'm
too.
going to ask this, essentially the same question I asked opposing counsel. Whose burden is it to show, or is it, what she may have earned or received from unemployment during the layoff? I mean, isn't that one of the factors that would go to whether the calculation under subsection B is a fair and reasonable calculation? And obviously, if you're applying B, you don't need that evidence. But is it up to the party who wants to apply the fallback to ensure that all of that information is on the record? Or is it up to the employee in this case to show, yes, but in addition to my earnings at Gendron, you know, I had some earnings from, you know, waitressing, and I collected unemployment, et cetera, because that's part of the calculation. With an injury, I'm also not going to get that.
Analogizing it to the seasonal worker standard, this court has said that employee doesn't have to prove that they're not a seasonal worker. The employer is required to prove that they are.
So is it your position that since it's the employer in this case who wants to apply the fallback provision of subsection D, that it is also their burden to show what earnings of any kind or income of any kind that she had during the period in order to show that the application of B is not fair and reasonable?
As you pointed out during Mr. Slunt's argument, D actually states that D is only used, and the wages that have been determined earlier, say under B, are not reasonable if the employee and other employees of the same class, comparable employees, are not making that rate.
Well, is the comparability the fact that many truck drivers, construction workers, et cetera, do get laid off in the winter months? I mean, do we account for that as part of the comparability?
No, I don't think so.
So let me ask the same question I asked of opposing counsel. You get to draft our guidance as to what test we should apply so that there's some regularity in how the ALJs and the AD are applying it. What do you think is the test that should be applied?
I think they would have to show that this employee's history did not include her working the hours that she worked. And she actually testified she basically worked 7 days a week and 12 to 15 hours a day. That's her history.
So you'd look at longer term at the history, not just the 6 years at Sargent, and you'd say, look at it over a span of time.
With Sargent, she worked those kinds of hours too.
But not 52 weeks a year, right?
No, because she wasn't given the opportunity.
Right.
And she wanted to. And the Alexander, that was my case. And this court ruled in that case that he had purposely chosen not to work year-round.
So we're crafting a decision that says, here's the guidance as to when you should be considering D. factor number one, should a disparity in what the person has ever earned and what, I mean, if they never worked full-time, that's a factor?
Right, that's what the statute kind of says. That's
And
what D says.
but it's just one factor, correct? And the other factors is voluntariness. Do you think that's a factor?
Well, if an employee that there is a case,
Right.
Bosse versus SAD 24, in which the employee chose basically not to work summers.
Right, so voluntariness, you'd say, okay, look at voluntariness, look at disparity. Are there look at the longer history of what the person is working. Are there any other factors you think that they should look at?
Well, D says two things: the employee's history, plus the what similar class of employees has worked. If you could show, for example, that the employee in this case they're basically saying they're a seasonal worker. And both hearing officers that decided this case says it was a backdoor attempt to have them classified as seasonal workers. And what's, I think, illustrative of what a seasonal worker is this court stated in the seasonal worker case that a seasonal worker is like a ski instructor, that's one example they gave, or a summer camp counselor. She was not either one of those. And in fact, her job, as she proved when she was self-employed and when she worked for other employers, if the work was available, she'd work.
But doesn't the employee get a windfall here? Because as we know, as a practical matter, she didn't work the 52 weeks, but her comp rate now is going to be based upon an average weekly wage as if she did work that period of time. Isn't that a windfall?
I don't think so, because her history is that she did work that. If you go back to the...
Well, it's been quite a few years, though, since she
Pardon?
has. I mean, it's been quite a few years. I mean, she was at Sargent for what, 6 years or something like that, earnings? I mean, it was,
years.
and Gendron before that. So we've got, 6, 8 years of, she doesn't earn that kind of money.
Right.
Well, we're talking about 2009 to 2015, 6 years, where she was working part-time, but before that, 2000 to 2009. I mean, it stops at 2015, so it's not like 20 years.
Right.
So we're only talking about a 6-year period where she wasn't working full-time. Is that correct?
Well, I think she was working full-time when she was working.
Well,
And they-
but
She
not
wasn't working
52 hours a
52
week.
weeks a year.
They actually paid her supplements that weren't included in her wages, and if you consider those, she'd be making more money. For example, she was paid, I wrote it down here somewhere, I'll see if I can find it.
But the basic question that I think we were getting at is that what she is if we use this average weekly wage, you're really attributing more money than she's earned, at least in quite a few years, if you annualize it. I mean, there's no question about that, is there?
Well, it's average weekly wage, not average.
I understand.
Yearly
But if you take $1,100 a week and annualize that, and I understand the average weekly wage is not the benefit, I get that. But, we're really saying a higher income than she can certainly show for at least a number of years,
Well, she would have made if she didn't get injured.
right? And what they're saying
And what
is-
she's capable of making.
I understand.
Okay.
But what they are saying is, if you annualize that, this is really more money than she has earned in years. And it shouldn't be a windfall. And it is more money than the attribution of $1,100 a week that works out to 60-some thousand dollars a year is more money than she has earned on the records that we have in quite a few number of years. Do you agree with that?
Well, no.
How do you not agree with
Okay.
that?
Well, for example, it doesn't include the value of the mileage supplement that she was given. That's not in her wage statement. I don't know where that is. But she was paid that whenever she had to drive over a certain number of miles in a day. She also received the hotel supplement.
None of that was considered by the ALJ here.
No, she testified about it. I don't know if he might have considered it and said, well, that's more money than she would have made.
Well,
And
the
another thing-
ALJ computed it based upon subsection B, did all the math completely correctly. But if that results in a windfall where she's getting average weekly wage that really doesn't correspond to the work history, doesn't that lead us to an unreasonable or unfair application?
No,
Why not?
because she's supposed to be compensated for what she could make.
In the computation of the average weekly wage, I thought I heard counsel interpret the statute to mean you look back to the previous year. Is that your understanding? That you only look back?
That's the way it's figured initially, but the legislature in this court, and I went back, I remember running into a case, I think it was back in the 1920s, where this court has said that you go down in a sequential and in the order of the different methods that are listed in section 102 to determine what the average weekly wage is.
But D is the only one that puts you looking back potentially further.
Well, C just puts you, says you divide by the total year.
Right. I'm just saying, you don't, I think it had to do with the period of the wage. It's the most immediately preceding period, right?
Right.
Until you other factors.
Well, you're supposed to look at what the employee's history is.
Right.
And what the class of employees in which they're working in, what their history is.
Does that class of employees, is that just limited to the specific employer, or are we talking about across the truck driving industry?
I would say, I think it's not clear, but I would say truck driving industry.
Can I ask you a philosophical question, a hypothetical question here? If you have an industry that lays people off with regularity at a particular time of the year, and that is simply the way it works, there's no flexibility to it, is that differentiated from seasonal workers under the statute?
Well, if you've worked more than 26 weeks, it wouldn't apply to you.
The seasonal worker.
Because it says it,
wouldn't apply.
yeah. It specifically says it. And they stipulated that she's not a
Now, in this case, the ALJ found that Ms. Bosse, and I quote, "did not choose to be laid off and would have worked year-round,"
Right.
end of quote, and that over time, in the future, if she develops seniority, she could be hired on a year-round basis.
Right, or they
By-
wouldn't lay her off.
Right. What difference would it make if Sargent didn't have year-round drivers? In other words, every driver worked 30 weeks a year and then stopped. Would that change the outcome here?
Well, she worked more than 200 working days, and she'd still be in B.
So you're saying that it's basically irrelevant what Sargent hired her, for how long she worked for Sargent, because she has lost earning capacity for the rest of the year.
Right.
Well, I don't think you really did, but answer what I thought was the original question. If, in fact, they don't work more than 30, let's assume the same, 30 weeks a year is what all Sargent employees work, and all of them get laid off. There is no potential for year-round employment for the drivers. Does that change the analysis? In other words, they all work more than 26 weeks, so we're out of the seasonal worker piece.
Right.
But they all get laid off. Does that change the analysis?
It depends if they look for other work when they do get laid off, which she did, or they collect unemployment, which I forget which one of you, I think one of you mentioned that earlier, that indicates that she was still employable, and especially with unemployment, you have to look for work in order to qualify for the unemployment. And I think what's important here is 5 of the ALJs found that the application of 102B was proper.
I understand. Thank you, counsel.
Okay.
Attorney Schlont?
Thank you, Chief Justice Stanfield. And to kind of piggyback off that hypothetical you laid out, if Sargent laid off all workers, that kind of seems
And
like...
rehired them in the spring, but
And rehired them in the
essentially,
spring.
they were all working 30 weeks or 35 weeks.
It's fitting that that's kind of the question I think that was posed by the analysis in the original Bosse with an I case involving a school cook who every summer was let go for the summer and then came back in the fall. In that court's analysis, the employer failed to provide the necessary evidence of earnings of comparable employees, so subsection D could not be
But aren't the
explored.
comparable employees truck drivers? I mean, it's not like a summer camp counselor. Truck drivers can work full-time 52 weeks a year as an industry, and she wanted to. And we're supposed to look at average earning capacity. So why isn't that 52 weeks a year?
The average earning capacity under the statute, the statutory language of subsection D, calls into consideration the history of the employee. The history of Ms. Bosse here at the time she was hurt was she did not work year-round. She did not work 52 weeks. There's about
But
a
if the
6-year
injury-
period.
If the injury prevents her from working as a truck driver during the remaining 22 weeks of the year, why shouldn't she be compensated for that?
Well, previously, the injury wasn't what was preventing her. It was the nature of the job, the slowdown in the winter that happened every year. The employer had, the winter happened, the slowdown occurred, and drivers were let go, and that's the position she was in year after year for about 6 years leading up to the
But
injury.
again, isn't that undercut by the fact that there were other employees who did work year-round? And there's a suggestion there may have been some sexual discrimination going on, but we're not going to go there. Not going to go there. But you've got a distinction here that with this particular employer, there are individuals who don't get laid off every year. So if you're talking about capacity, or earning capacity as opposed to actual earnings, isn't that problematic for you?
No, Your Honor, I don't think so, because I think Ms. Bosse testified that she knew that there was no, while some workers did work during the winter, she knew that it was likely she would not work during the winter. She knew that she was going to continue working in the same pattern that she had
But
previously
she also
worked.
said that she would if she could.
She would if she could, but she knew she couldn't.
What is the test for what's unfair or unreasonable? I understand your argument that there's a windfall here, there's a disparity, but how do we draw the line?
Well, I think once, if subsection B is applied and it's argued that it's unfair, I think that and I think one of the elements you could look at to see if it's fair or not is whether or not the annualized average weekly wage exceeds what the employee earned in the
Yeah,
past.
but you just said that's one of the factors. We understand that. We're trying to figure out what you suggest are the other factors. Or are you saying just if it's a lot more, per se, unfair and unreasonable?
I'm saying that's the primary factor you look at the B analysis, and then once that's determined, you move on to D, and at D is where the judge takes into all factors: unemployment, imputed minimum wage if desired, whatever evidence is presented to show what the employee likely would have been able to earn during that layoff period, because we know it wasn't what she was earning while she was working.
Thank you, counsel.
Thank you.
Thank you for the argument here this morning. We, of course, will take this matter under advisement, issue a written decision in due course. I also note, counsel, that it's your first appearance before this court, is my understanding. As is our usual practice, we invite counsel all to come back and take the greetings of the court.
All rise.